I permitted to my lord mention one matter, my
Yes.
lord, is running in my lord's list. My lord, this is with respect to my lord, the order of the learned tribunal, my lord, where my lord there has been a direction for reinstatement in the service, my lord, and challenging that the central government has preferred the instant appeal. During the pendency of this appeal, my lord, their reinstatement is allowed, and they are right now reinstated and has been working. So, my, I just beseech your lordship, if your lordship could, my lord, accommodate this matter, my lord, any day in the next week at the top, I will be informing
You are for?
for the respondent, original applicants. So I say that this writ petition is right now, my lord, infrastructure subject to lordship.
So what is the big deal? You have got what you want. Let
But,
it be pending.
problem I am facing with respect to my pay in the before the department.
But it's not your appeal. It's not your writ
Mine,
petition.
It's not mine. my lord.
You cannot mention it. It will have to be mentioned by the writ petitioner. Unless there is some interim order and you need a vacation of the order, you may. But that's not the situation. Therefore, we are saying, if come together, then we can,
as your
maybe
lordship,
we can consider.
as your lordship please. As your lordship. Great.
Regulation item number 1.
The affidavit of service is not yet ready, my lord. Kindly keeps it not this week.
Why? Why affidavit of service is required? There is a direction.
I'm upon limited instruction by my seniors.
If there is no direction, where is the question of affidavit of service? Proceed on merits. You are for the applicant. You are for the applicant.
Yes.
Let's proceed on merit. We'll see whether the notice is required, they are required or not. Union of India has filed the writ.
Yes, my lord. I'm not the member of the panel. My senior is appearing on this behalf.
Not today. Ask him to be here.
Sir, kindly keeps it not this
No,
week.
not today. Call the next case.
Item number 2. But service could not be made to the respondent, sir. Service. My lord, my application for family pension,
Application for?
family pension, other than spouse, was rejected. But the main question is this: that the very I have obtained my certificate from the district designated hospital in Bhadok, wherein it has been declared that I am 60% disabled. 60% disabled, I cannot work to earn my life. So that's the railway authority further was an further constituted a board by 3 doctors. In my case, my 4 doctors was examined. 4 designated doctors were examined me, and they found that I myself is a disabled person. Whereas they have rejected, kindly, your lordship may kindly annexure 46.
Annexure 46.
Yes.
There are 46.
Page 46, not. And page 46. Annexure P9. It is regret to inform you that grant of family pension case under other than spouse ground has not been considered by the medical board. Central Hospital, Southwestern Railway Garden Dish consists of 3 doctors. As you can earn your own livelihood. There is, except in this paper, this single piece of paper, they have not intimated the findings of the doctors. What they have found myself after examination, they have not sent any such of documents to me. Simply by this way, my application was rejected. Whereas, sir, I have also examined by designated doctors of Bhadrok Hospital, District Hospital.
Why you did not appear before the tribunal? Why have you not appeared before the tribunal
The,
on several dates?
because of the fact that I have not been properly instructed that to file this before this.
You have not been instructed. What not instructed? This is the order you are challenging. Paragraph 4 says that not been represented on last several occasions. 1, 2,
Yeah,
3,
I have
4
explained.
dates.
I have explained, sir.
Where have you explained?
I have explained.
Where is that? 5 dates you have not appeared.
Not a fact, madam. My lord, that
Not a fact.
sir, no, I did appear. Only 2 occasions I didn't appear.
Sir, there are 4 dates noted herein.
I have.
You have not filed a review of the order. You cannot say it is not a fact. It is an admitted fact now. If it was incorrect, you are required to point it out to the forum in the. You are required to point it out to the forum by filing a review, which you have not done. Therefore, you cannot say it is not a fact. It is a fact. How you have explained, let us see.
My lord, I have annexed entire orders.
What have you said in your writ petition? What have you said about these 4 dates which have been mentioned in paragraph 4? We are not going to doubt the recording of the tribunal because the lawyer says so.
I have not categorically mentioned, my lord, this fact that I have not categorically mentioned.
Then
But I have
it's an admitted
annexed-
position. Then what is wrong with the
I-
order
I-
we are asking?
I have annexed all the documents.
We are not going to see it. Why should we? We are not an appellate forum, first of all. Second of all, these facts are conclusive, not disputed. You have not asked for a review. This is a recording of fact.
That's fact that I have
Then
not asked for.
it is an admitted position. Why you should not appear for 5 dates? Tell us. And why it should be kept pending for the 6th date?
Your lordship may come on page 9 of my petition. Page 9 of para 5. I have categorized here each and every date. Each and every date. What happened in the court? On 9/10/23, advocate appeared for the admission notice issued returnable in 6 ways. 29/11/23, responded to press for time for filing reply. 2023, advocate for the respondent further press for time of reply. This way, proceedings were going on.
It has been decided on merits. You are not telling us. In your absence, it has been decided on merits after considering the respondent submission. Serve a notice. 1 week for serving notice.
Valid 17. Valid at the cost of admonition, valid.
You have some special status that you can come and start making
Valid.
submissions at any time.
No, valid.
Call the list.
Number 3.
None appears for the writ petitioner.
Number 4.
In this matter, my lord, I am appearing on behalf of the respondents. Mr. Sanyal, senior advocate, he appeared on behalf of the petitioner.
Huh?
Mr. Sanyal, Subir Sanyal,
Huh?
he appeared on behalf of the petitioner and has completed his argument on behalf of the petitioner. Now, my lord,
You are for the respondent.
I am for the respondent.
In the order sheet, last date, your odd name is appearing for the petitioner.
Pardon?
In the last order, your name is appearing for the petitioner.
That will be wrongly recorded. Wrongly recorded. Let that be corrected, my lord.
Yes. Because in the order prior to that, you are shown as appearing for the Union of India.
Although I am appearing on behalf of the respondent.
Where is Mr. Sanyal?
But he has completed his argument.
Still, he should be here when you make your submission.
Junior
right.
is here.
All right.
I may place my submission. He may take the note. She may take the note, Millard, and if request, Mr. Senal may reply again. But this is a matter.
Graduate apprentice.
Yes, here two sets of thoughts have been expressed up till now. Millard, one by the court by way of observation, whether on the self-same issue consecutive writ applications can be possible or not. And Millard, the second thought which has been up till now has come out, that is from the petitioner. Millard, my learned friend Mr. Senal has submitted before the Honorable Court that second consecutive writ application is can be done, and he has submitted certain decisions of different courts to satisfy your lordship. Now, what happens according to the petitioner? If an order is passed in a writ application and that is partly complied with, even if contempt is filed, then for part compliance, contempt may be dropped. But the petitioner should not remain without remedies for which second or subsequent application, writ application can be done. This was his submission. He relied upon the documents which I have noted, I have come across. J.S. Parihar versus Ganpati Digar, 1996, Volume 6, Supreme Court cases. Then 2007, one Supreme Court cases, State of Haryana and others versus MP Mohalla. 2007, 7 Supreme Court, that is Commissioner, Karnataka Housing Board versus C. Muddaiya. 2003, Volume 1, Calcutta High Court Notes, Vivekananda Mandal versus State of West Bengal, and 2011, Volume 5, Calcutta High Court Notes, Dhiren Soren versus State of West Bengal. These are the documents which have been filed. Now, Millard, the 1996 Supreme Court is the basis, relying, that is Millard Parihar's case, relying upon which 2007 Volume 1 Supreme Court order was passed. That is State of Haryana and others versus MP Mohalla. Now, 2011 Calcutta Law Journal decision was passed relying on AIR 1983 Patna and also 2007 Volume 7 Supreme Court. The observation made by the Honorable Court and the argument advanced by the petitioner, both have been, Lordship, both have been made on the issue whether consecutive writ applications can be made to obtain full-fledged relief. Now, my humble submission is this. In a reply, I should not have gone into the facts, but if I do not draw your lordship's kind attention to certain portion of the facts, then I believe, my argument would be incompleted. From the aforesaid observation made by the court, the arguments made by the petitioner in reply to such observations are omnibus in nature. All these orders which were passed, decisions have been placed by your lordship, before your lordships, are omnibus in nature, and petitioner's alleged grievance has not been adjudicated therein. But I do not object to those decisions, as because those are very natural. I also support those. Now, my lord, my humble submission is related to the alleged grievance raised by the petitioner. My lord, this is the third phase of writ application. Now, my lord, grievance of the petitioner is this, that he completed 4 years bachelor degree course in mechanical engineering and also completed 1 year graduate railway apprenticeship training under the Apprenticeship Act 1961 from Chittaranjan Locomotive Works and held Certificate of Proficiency granted by Ministry of Education, Government of India, formerly known as Human Resources Development, and also completed 6 months vocational training in the trade of electrical housing ware and motor winder. my lord, this will appear from, my lord, page 71. Now, my lord, this apprenticeship training scheme, etc. The petitioner initially applied for the posts of substitutes in Chitronia locomotive vacancies along with others. As their cases were not considered, they moved original application number 1556 oblique 2018 before Central Administrative Tribunal, Calcutta. The tribunal, by order dated 9th of October 2018, directed the respondents to pass a reason and speaking order within the time stipulated. That order is, my lord, dated 9th of October 2018, will appear from page 114. A11, my lord. That is, my lord, annexure. Now, speaking order was passed rejecting the representation made by the petitioners. That would be, my lord, at that was passed on 20th of February 2019. It will appear from page 117. Speaking order to 117. Lordship kindly allows me to read speaking order portion. I shall not disturb your lordships.
No, in fact, we are trying to recollect things. It has been
Right,
a long
right,
time.
right.
Oh,
17. 117. But this was the speaking order.
Page,
Page 117. Annexure A12.
this was challenged before the tribunal.
No. This was the first page.
First,
Then, my lord, I am coming to the last portion. Sri Moina Goswami and others have represented by their letter dated 1st September 2018 for their engagement as substitutes. Since the engagement of course completed ACT apprentice as substitutes has been discontinued by Railway Board, their engagement as substitutes in Group D is not feasible. They may apply against notification issued by RRB/RRC for their appointment in railways. Representation dated 1st September 2018 is accordingly disposed of. But this was the speaking order. Then, my lord, lordship kindly consider that Railway Recruitment Council, they issued notification 01/2019. 118, my lord, page 118, annexure A13. If your lordship will come to clause 6 of the same, that will appear at page 126. 126. No, that's what one. Clause 6.0. Well, this is educational qualification which has been mentioned there. Have your lordship got?
yes,
Page 126, annexure 13. Candidates should have requisite minimum educational qualification indicated for posts in annexure capital A of this CEN from recognized board/NCVT/SCVT as on the closing date for online registration. Those awaiting results of the final examination of the prescribed minimum educational qualification should not apply. Note, diplomas as degree.
before that, what is the date of this notice? Employment.
This- Yes. This was issued on.
So immediately after the speaking order.
Yes.
In fact, 2 days after the speaking order.
Yes. Yes. 23rd of February 2019.
The speaking order has been communicated on 20th February.
Yes.
So just 2 days thereafter.
Yes. And it was mentioned that it is going to be notified. He may participate there.
No, is that
In the speaking order, it was mentioned.
where can we
In
find
the
this?
last portion also, can you see?
In fact, we don't find, therefore we are asking.
Again, I am reading.
Yeah.
Sri Moina Goswami and others have represented by their letter dated such and such for their engagement as substitutes. Since the engagement of course completed act apprentice as substitutes has been discontinued by Railway Board, their engagement as substitutes in Group D is not feasible. They may apply against notification issued by RRB/RRC for their appointment in railways.
So it is open-ended. Any
Subsequent
notification issued, you may apply. It is not with reference to this notification which is
Yes.
coming 2 days after.
Yes. But it was mentioned therein that this should be done and they may participate.
Yes.
Then Lordship, I have shown your Lordship.
126. Clause 6, 126.
Yes, 126, that is educational qualification. Then Lordship, can you come to page 129?
Just a minute.
Yes. Have your Lordship got cooler?
Yes, sir.
Okay.
So they are graduate apprentice.
Yes.
So 6.1 says they are ineligible.
Yes. Now, my Lord, Lordship, can you come to page 129?
129.
Yes. Clause 09.1. This CEN provides for horizontal reservation for ex-servicemen, course completed act apprentice, CCA, trained in railway establishment, and persons with disabilities, PWBD, in respective of their community. It is there. Then Lordship, can you come to 134 page. Here, I will invite your Lordship to clause, my Lord, 12.1. Have your Lordship got cooler? Railway Act apprentices. The vacancies to be filled from among the course completed Act apprentices trained in railway establishment and possessing National Apprenticeship Certificate granted by National Council of Vocational Training is separately indicated in the vacancy table. This will be in the nature of horizontal reservation, as in the case of persons with benchmark disabilities and ex-servicemen. However, unlike in the case of PWBDS, that persons with benchmark disability, there will be no carry forward of the unfilled vacancies to be filled by this mechanism. In case of shortfall, the vacant slots shall be filled from other in the combined merit list. Then, my Lord, 11.2 Lordship can come to page 135. Next page. The last date for registration of online application, that is on or before 12th April 2019 of the CN, shall be the cut-off date for completion of apprenticeship. A candidate shall be considered to have completed this Act apprenticeship training only if he has appeared in the NCVT examination before the last date for registration of online application, that is on or before 12th April 2019 of this CN, and result in which might not have been declared. However, the candidates should submit the NSS certificate issued by NCVT during document verification, failing which he/she shall not be eligible for reservation as CCAA under this provision. Then, Lordship, petitioners were not permitted to apply against notifications so issued since these were reserved for course completed act apprentices because of 20% horizontal reservation. That's why, my lord, petitioners moved second original application.
No,
Second
but
original
if
application is number, my lord, OA 322.
you have read 6.0 from this notification,
6.2.
6.0,
6.
page 126, 6.0. If the graduate apprentice are not eligible, then where is the question of relying upon the other portions?
Pardon, my lord?
The petitioners are graduate apprentice. So 6.0 says that they are not eligible.
Yes.
Then how the other clauses are relevant? If
But they have got the certificate not from the railways. They have obtained the certificate from Human Resource Development Department. That's why
Certificate-
it is specifically mentioned therein that this is the criteria. If it is fulfilled, you will apply. If it is not fulfilled, you will not.
No, they have got from Human Resource Department what certificate?
But this is the criteria which have been laid down therein, which I am just placing before your lordship.
No,
I cannot go.
what we are asking you is they have a certificate issued by the Human Resource Department.
Yes,
You say that is required to be done by the railways.
yes.
But the railway, even if it is a railway, this 6.0 says graduate act apprentice will not be accepted.
Yes.
So if they are graduate apprentice, then can they participate in this process?
No, whether graduate or non-graduate is not the criteria. Criteria is whether they have been trained under railways or have obtained certificate from NCVT or means National Vocational Training Center.
National Council for Vocational Training.
Vocational training or State Council for Vocational Training. But they have not got it.
So it is required to be from NCVT
Yes,
only,
yes.
not even from
NCVT or SCVT.
or SCVT.
Yes. And during verification of the documents, while respondents asked them to produce certificate and got them opportunity to submit that, they failed.
They never produced.
They never produced. Now, my lord.
So in this writ petition, is the certificate on record?
Pardon?
Is the certificate on record in this writ petition?
Yes.
Where is the certificate?
দেখো ফার্স্ট একদম অ্যানেক্সের এটা হলো না আরো আগে চিত্তরঞ্জন লোকোমোটিভ Lordship, kindly come to page 79. A1, annexure. National Apprenticeship Training Scheme. Ministry of Human Resource Development. Certificate of Proficiency. This is to certify that Sri Moina Goswami, son of such and such, graduate apprentice has undergone apprenticeship training under the Apprenticeship Act 1961 as amended in 1973 at Chittaranjan Locomotive, Bardhaman. This was issued, my lord, by the Ministry of Human Resources Development. Have your lordship got it?
Yes. So
Now,
this is
lord-
not issued either by NCVT or SCVT.
Yes. Now, my lord, they moved original application again before the Central Administrative Tribunal, that is number OA 322 of 2019. That will appear from, my lord, the order will appear there from page 160, annexure A16. This is dated, my lord, 12th September 2022. My lord, in compliance of the order, petitioners, my lord, may I place the order, my lord? 162. 163, yes.
You have given an assurance in paragraph 7 of this order.
This order passed by the Central
Tribunal, yes.
Tribunal in 322,
Paragraph 7.
Lordship, paragraph 7. Yes, Learned counsel for respondents, however, assures that applicants shall be allowed to participate in the ongoing selection process in the event the said process is not yet over, but preference will be given to course completed act apprentice over graduate apprentice as per rules.
So no issue of NCVT or SCVT is raised. It
That
is
is
only that the graduate will not be given. They will be the CCAA will be given preference over graduate.
Below, this is submission on the part of the respondents there. What was the order? Order is, my lord, at paragraph 10.
Yes, we have seen that.
Yes, in view of the fact that minimum requirement is that of matriculation and course completed act apprentice certificate, and that course completed act apprentice may get preference over others in the selection process. Applicants, the graduate apprentices, are well within the right to participate in the selection process and being considered. Therefore, next page, Miller. Such applicants who have applied shall be allowed to participate in the examination, and based on their performance, they shall be duly considered against the vacancies if nothing else stands in the way. Paragraph 11. We allowed them to participate. They participated.
So even those who were ineligible, they were allowed to participate.
Yes. They are allowed. Well, this is a court's direction.
No, you
Tribunal's
have.
direction.
That's why we are saying paragraph 7 is your assurance to the court.
Yes, my assurance was also there that they will get participation. They would be allowed to participate. Nothing more, nothing less. And it was specifically mentioned there that we stated
So is
that,
that
but preference will be given to course completed act apprentices over graduate apprentices as per law.
so such assurance,
Yes.
is it in line with the notification for recruitment?
No,
Therefore, we are saying.
that was not true. Because sometimes without instruction we have to work.
Yes.
Lordship, with your vast experience, knows. Sometimes Lordship was here, knows how government.
Very well. We are just trying to be clear on facts.
Yes.
Therefore, we said because as per the notification, it is your case unless NCVT or SCVT,
Required.
they cannot.
They could not.
But before the tribunal, you said let them participate on their merits. This was the crux.
Yes.
If nothing else stands in their way, they will.
Yes.
So therefore, you have kept everything open.
That's why Lordship sees in compliance of the order, petitioners are allowed to sit in the recruitment examination, but failed to produce certificate passed in railway authority, being course completed act apprentice, or certificate issued by the NCVT or SCVT. Hence, their names were not placed in the panel of successful candidates. Now, my lord, petitioners move third application. That is original application number 808/2023, wherein my lord, order was passed on 5th of September 2023. This will appear at page 253, my lord. No, 253. After page 253. This is the ordering portion.
Where is the result of the process first? Which page?
Lordship.
The result in which their name was not figuring. Where is that result first?
Their names were not there.
In which result? Where is that result? What is the date of that result? Provisional panel 27/4/23.
Yes. List देखो.
Just see page 169. This is the panel.
Provisional panel, part panel against the CN1 of 2019. Yes,
So this is the panel.
yes.
Their name is not figuring in this
No.
panel. Yes. Then came the
Then
third
law-
way.
Then petitioner moved third original application, that is number 808 of 2023. Wherein order was passed on 5th of September 2023. This will appear below after page 253, and if your lordship kindly come to, yes, ordering portion, my lord, ordering portion.
So this is the third way.
Third, against which, my lord, this application has been. Now let council therefore submit the response, my lord, to some extent, my lord, from paragraph 2.7 shall I read?
You may read whatever you want to place.
Yes. This is your internal page 4.
Yes.
After page 253.
Yes,
my lord,
we are there.
it is stated that clause 6 of the said CN prescribe educational qualification wherein it has been stated that candidates should have requisite minimum educational qualification indicated for the post from recognized board /NCVT/SCVT. Further, in note as mentioned in the said clause 6 under the head educational qualification stipulates note diploma/degree in engineering will not be accepted in lieu of course completed act apprentice/ITI also. Graduate act apprentice will not be accepted in lieu of course completed act apprentice. Then 2.8. In response to the application submitted by the applicant, he was issued admit card and is sat for the written examination as CCA candidate. As per the result declared of the said examination, he was awarded normalized marks 54.59793, that weightage under CCA category, Annexure A18 refer. Thereafter, he was called for document verification and medical verification scheduled on 25th February 2023. Annexure A19, Miller. 2.9. It is also stated that the applicant that total 20,734 posts which were reserved for CCA category. In response to it, a total of 2,175 were allotted to Eastern Railway, Metro Railway, and CLW, which is under the control of RRC/Eastern Railway. Out of 2,175 posts in respect of CA agency category, a total of 1567 CCA candidates, including applicant, were shortlisted for document verification and medical examination. 2.10. It is stated that at the time of document verification process, the workshop personnel officer, WPO, who was the in charge of the document verification process, did not accept the apprentice certificate of the applicant as stipulated under the head of detailed CN as well guidelines of the document verification process. 2.11. Thereafter, the applicant filed his grievance/petition application before respondent number 1, considering him against reserved post under CCA category. In response to it on 29th March 2023, respondent number 1 replied to the effect that policy of Railway Board is to provide 20% horizontal reservation in recruitment to level 1 posts for course completed act apprentices trained in railway establishment CCA and for national apprentice certificate NAC from NCVT, and since degrees as diploma holders do not possess the requisite eligibility qualification, they are not eligible to get the benefit of 20% reservation earmarked for CCA candidates, that is Annexure A20. Now, 2.12. Subsequently, the petitioners have published a panel of selected candidates on 27 April 2023, that is Annexure A21, wherein the name of the applicant has not been included. Thereafter, the respondent number 4 revoked all the provisional part panel list including Part 1 panel on 13th June 2023 on administrative regions and reissued provisional Part Panel 1 of all categories of candidates, hence this way. It is submitted that note below paragraph 6 of the CN 01/2019, speaking of non-acceptability of diplomas as degree in engineering in lieu of course completed act apprentice, CCA, but it does not speaking of non-acceptability of degree in engineering and also possessing course completed act apprentice. According to the applicant, the said paragraph 6 of the employment notice is restricted only to those who have only diploma, degree or ITI certificate but does not possess apprenticeship certificate from other organization on the same has no manner of application in case of any candidate who possess apprenticeship certificate as well as degree in engineering. 3.1. Further, it is contended that in the year 2018, the respondent number 1 had issued CN 2/2018, wherein total 12,445 posts were reserved for CCA, and in connection with the said notification, a number of diploma railway apprentices joined from various zones under Ministry of Railways, which shows the arbitrary discrimination being meted out to the applicant herein by not accepting his candidature under CCA. 3.2 million. It is stated that some of CCA candidates who have NCVT certificate is going to get appointment in railways. According to the applicant, such candidates who have secured less marks than the present applicant, but due to NCVT weightage, they cleared the minimum qualifying criteria as laid down in para 14.1 of the current employment notification, that is CN 01/2019, which is not permissible under law. The applicant, by referring to the judgment passed by the Honorable Apex Court in case of Dinesh Kumar Kashyap versus South East Central Railway in civil appeal number such and such, Narendra Kumar versus State of Punjab, Narendra Kumar versus Hindustan Insecticides, judgment passed by Delhi High Court, judgment passed by the Honorable Supreme Court in UPRSTC, UPSRTC versus Shisu Sikha Berozar Sangh would submit that since there exists unfilled vacancies under CCA category in respect of present CN, applicant's case ought to have been considered by the respondents and he ought to have been offered employment. Learned Counsel therefore submits that the respondents have arbitrarily not considered course completed act apprentice from railway organization employment in spite of having NSC issued by the government, and therefore discriminated the applicant, and the said action is in violation of the provisions contained in Article 14 of the Constitution. Now 5. It is stated that paragraph 6 of the CN, more particularly restriction imposed by way of note below to the said para, is contrary to the instruction issued by the Railway Recruitment Board, and same ought to have been inserted in the vacancy notice. Had the Learned Counsel for both sides at length and examine materials on record at the outset, it is required to mention that it is settled principle of law that once the candidate participated in the recruitment process by accepting the terms and conditions stipulated in the vacancy notice, and thereafter on being declared unsuccessful, it is not open for the candidate to turn around and challenge the legality or validity of the terms and conditions of the said vacancy notice. At this stage, it is profitable to refer to the law laid down by the Honorable Supreme Court in case of Union of India versus N. Murugasan, 2020, Volume 2 Supreme Court cases, where it has been held, party cannot be allowed to approbate or reprobate. The unselected candidates cannot phrase into service a part of the 1978 rules while accepting the 2025 rules by taking part in the selection process, thus one cannot blow hot and cold. Such a selective adoption is not permissible under the law. In the present way, undisputably, the terms of the vacancy notice, that is CN 01/2019, dated 23rd February 2019, the applicant had submitted his application and participated in the selection process. It is apt to mention that the note below to para 6 of the said vacancy notice stipulates that diploma degree holders in engineering will not be accepted in lieu of course completed act apprentice/ITI. Also, graduate act apprentice will not be applicable in lieu of course completed act apprentice. It is also not in
Now
dispute.
just read here, please, a bit slowly.
Yes.
It is also not in dispute. What you
Yes,
are
yes,
just reading.
yes.
Yes.
It is also not in dispute that applicant possesses educational qualification of having first graduate railway apprentice and national apprentice certificate.
So they use the admitted positions is that they have the NAC certificate.
They took the training in
Ah.
Chittaranjan locomotive works. That's why they are telling that this is railway. But this was issued by the Ministry of Human Development. This is I have shown your lordship annexure.
No,
E.
but just a minute. We are trying to understand your case. You come back to this
Seventy-nine.
page 5 of this order,
Right.
paragraph 2.11. Policy of the railway board is to provide you have 2.11
Yes.
is page 5 of the CAT order.
Yes. Therefore,
Policy
the
of-
applicant filed his petition/application before respondent number 1, considering him against reserved post under CCA category. In response to it, on 29 March 2023, respondent number 1 replied to
That
the
was
effect-
your reply. What was
Yes.
your reply to the effect?
Replied to the effect that the policy of railway board is to provide 20% horizontal reservation in recruitment to level 1 post for course completed act apprentices trained in railway
And in
establishment.
Railway Establishment Act, in the railway establishment,
Yes.
not training certificate issued by railway establishment. Trained in the railway establishment
Yes.
for course completed CCA apprentice
Eh,
trained in.
And for national apprentice certificate.
So there are two kinds. One is the recruitment to those who have done their CCA and in the railway establishment, and the other is NAC from NCVT.
Yes. But Millard,
So are they the petitioners not?
my humble submission before your lordship is this. If someone takes training in Chittaranjan locomotives, but certificate is not being issued by the Chittaranjan locomotives, then where is the proof that he took training in Chittaranjan locomotives?
No, there is no proof. He is saying so. Have you said that he was not trained in the Chittaranjan locomotive?
That's why
Where have you said that he was not trained in the Chittaranjan locomotive center?
no, we have not. we
So
are not
therefore,
saying-
this is a fact
that
asserted.
thing is That certificate was not issued by the railway.
This doesn't say.
Chittaranjan locomotive is the part of railway.
It says trained in railway establishment.
We will have to read entire thing at a time and not in a piecemeal way.
Obviously, therefore we are saying therefore it has to be your case that CCAA issued by the railway. That only we are entertaining, and for that we have 20% reservation.
Yes.
The rest is NAC issued by the NCVT or SCVT. So these are the two kinds of certificates which we recognize.
He is seeking that 20% reservation,
Correct.
but he must have to prove that he took, he participated in railway training. So the certificate, we will take him. Direct him to produce the certificate issued from railway.
No, that is at page 79.
Lordship?
That is at page 79. You have already shown.
Yes, Lordship, kindly come to, I invite your Lordship to take the trouble again, my Lord.
You say that the certificate is at page 79.
Yes.
Now see whether it says Chittaranjan Locomotive Works or not.
Lordship, can you see National Apprenticeship Training Scheme,
Correct.
Government of India.
At which place?
This is to certify Mohina Goswami
Chittaranjan.
Chittaranjan Locomotive Works.
Correct. It says so on the certificate.
But Milord, this was done under Ministry of Human Resources
So
Development.
therefore, now you say, when you say everything has to be seen and not piecemeal, therefore we are asking you. Everything has to be seen. So, does the railway issue such a certificate? Or the certificate is issued by the ministry and his training is done in the establishment?
Lordship, who signed the certificate? Director of Regional Central Apprenticeship of Board of Practical Training, Eastern Region.
Correct. It is by the Eastern Railway.
Where is this Eastern Railway? Eastern Railway is
Eastern region, sorry. But
Eastern region.
does the railway issue such certificate?
Is in other cases, those who have taken, training in railway, they have been given that certificate.
We are trying to understand. You are making a distinction. There are two kinds of certificate. TCAA, issued by after training in railway establishment. For that, there is 20% reservation. Then there is NSC, issued by NCVT or SCVT. That is these are the only two certificates which are entertained for this recruitment. They are not claiming NSC. They are claiming CCAA. They are relying on page 79 certificate issued therein, which says the training was undertaken at Chittaranjan Locomotive Works. You say this is only done there, but this is not issued by the railway.
Yes.
So, is there a system where the railway issues the certificate, or this is the system? We are asking you that.
I will have to take instruction.
Because why we are saying so, just now you have read the order of the tribunal where it says done in the railway establishment, not certified by the railway.
Yes.
So since it is done in Chittaranjan Locomotive Works, certified by the National Apprentice Training Scheme, we don't know that there is a gray area here. Therefore, we are asking,
Right.
what is your case? Do the railways issue such a certificate?
This is issued by the locomotive authorities, a part of the railway.
This is not issued by the locomotive authorities. This is issued by the National Apprentice Training Scheme. This is by the government of India, not by the railways.
But to that extent, I will have to take specific
Please,
instruction.
if you have understood what we are,
I've understood. I've understood.
otherwise, if the railway does not conduct such an exam, then we don't know.
Obviously.
Maybe this will suffice for them to participate or be.
Right.
If the railway conducts such and issues a certificate, then you may or may not have a case that we will have to see.
Give him not one opportunity to get.
You understand what we are saying?
And I shall please reply.
After the some
Twenty-five.
Item number 5, your lordship, I am appearing on behalf of my learned senior. He is engaged in a Port Blair circuit bench matter. I am praying for a short pass over here.
He is in Port Blair.
No, he is not in Port Blair. He is here appearing online in a some matter. So I am praying for a short pass over, your lordship.
Not today. Ask him to come tomorrow. Not today. Come tomorrow.
26.
I'm applying to the state.
Lordship, on the last occasion, we prayed for to submit the exception of the report, your lordship.
You prayed for?
To file the exception, your lordship.
My affidavit in opposition. Affidavit in opposition.
You are filing in 8. They are all together, coming together.
In item number 6, I am applying for the state.
6 to which number?
Item 6 and item 8.
Only 2.
First 6 is being.
You are appearing in both.
I am appearing in
Both.
in item number 6. This is my reply.
6
It 8. 6 has been given, my lord. This is in respect of 8. I am giving it later, my lord. Have 6.
And you are appearing in Mr. Mukherjee is appearing. You are not appearing in 6.
My lord, this petition are contractual.
Just give us 2 minutes. So where is the advertisement with regard to which you are claiming?
First advertisement, my lord, is at page 62. And the relevant portion is at page 63. Kindly mark the number and date. My lord, I will take your lordship to the relevant portion, page 63.
What is the date of this advertisement?
Date of this advertisement is
Sometime in
as such is
2020.
2020.
Yes.
21st July
21st July 2020.
My lord, at 64, your lordship will find the date. My lord, 63 is the relevant portion. If your lordship kindly comes to the note. Note, my lord, 6.
Note 6.
My lord, may I read for you? The claim of candidates for relaxation of age as regular employees, government employee, regular oblique contractual government employee should be proved. My lord, here, my lord, if your lordship sees, age relaxation has been given to both regular employee and contractual employee. And now, if your lordship kindly comes to the next advertisement, which they are saying, second advertisement, I am saying, my lord, at page 65.
So this note has to be read with the proviso
Yes, my lord.
at page 63,
Yes, my lord.
provided that the age, read at the top,
Yes, my lord.
after desirable, there is a column age.
Provided that the age may be relaxable for the candidates belonging in case of this is a general relaxation, age relaxation. That OBC and scheduled caste will get an age relaxation as is applicable in our state.
From the withdraw.
My lord, in addition to this, a candidate, a regular employee or a contractual employee, for availing STSC and OBC relaxation, my lord, if a candidate is an OBC or ST, he will get. But every candidate who is not even an OBC or an scheduled tribe or scheduled caste will get a relaxation if he is a regular or a contractual employee, according to this advertisement.
What relaxation? If note 6 is to be read, the horse, the proviso, then what relaxation? 1 day. 1 day relaxation.
No, my lord.
Then,
Suppose, my lord, I am a general unreserved candidate.
yes.
My lord, I am not getting any age relaxation without, if there is no note 6. I am a regular unreserved candidate, general candidate. I am not entitled to any age relaxation. But if note 6 is there, my lord, then being an unreserved candidate or an OBC candidate, in addition to, my lord, suppose as an OBC, I am getting a 3 years relaxation of age from 40 to up to 43. If I am an OBC, I am
Can't
entitled
mix the two. You just now said whether OBC, SC or ST, that is immaterial.
immaterial.
It is general person will get a relaxation in terms of clause 6,
Clause 6.
note 6.
Note 6.
So this note 6 gives relaxation to everyone
Everyone.
who is in government or contractual employee.
Contractual.
How much? 1 day.
My lord, that has to be decided by them. They will decide. My lord, kindly say.
Doesn't say so.
My lord, kindly, my lord, may I read for my.
Yes.
Otherwise, this note 6 will be, my lord, will have no application.
Exactly. That's what we are saying. It has to be read along with the proviso above,
My lord,
which says that SC, ST, OBC candidates will be allowed age relaxation, and if they are seeking this relaxation in respect of the work performed, then they have to give the proof.
if they,
And if it is read separately, then to what extent we are asking?
my lord, if I,
Both conditions, as of now, it is possible.
yes,
But this note 6, if it operates in isolation, then how much relaxation?
my lord, relaxation, they are.
And where does the advertisement say that for this the authority will have the power to decide?
My lord, may I read note 6 for my satisfaction?
Please, yes.
That the claim of candidates for relaxation of age as regular oblique contractual government employee shall be proved by a certificate from the appropriate authority during the period of candidate continuous service. My lord, this if I am a general candidate and I am a contractual employee, I want age relaxation for participation in this recruitment. Then, my lord, I have to apply showing that I am working as a contractual employee. And if I am working as a contractual employee, irrespective of my age, my lord, I will be allowed to participate in the recruitment process. And this has also not the case of the respondents also.
So,
Here, my lord, a
if your submission is accepted, then you may be 56 years old at this time. You may be working on contractual basis, still you will be allowed.
yes, my lord, that has been done in case of regular employees. My case is regular employees, this age relaxation has been given, and that is their case in the opposition. They are saying, no, we will not give any age
They
relaxation.
are giving to regular.
Yes.
Where is that source?
Yes, my lord. This is the first advertisement I am talking about. After this, my lord, if your lordship kindly comes to page 65 once. They are saying that no, this is the only advertisement that we have published. And my lord, relevant portion is at page 66.
What is the difference? Both are of the same date.
Yes, but they are saying this is the only advertisement. First advertisement, they are denying. No, there has been no advertisement. The first advertisement, they are saying there is no advertisement. We have not issued that. They are only saying they have issued this advertisement.
What is the difference between the two we
Okay,
are asking?
Kindly come to page 66. Kindly come to my lord, note 6. They have omitted the word contractual. And this, my lord, lead to the filing of this application before the tribunal.
They say that this 62 has not been issued by them.
They are saying 62 has not been issued by them, and the tribunal is saying, giving that since a responsible government officer had said so, I am believing it. This is the reasoning the tribunal has given.
So before the tribunal, you have annexed this page 62.
Yes, yes. Both the I have annexed, my lord. Before the tribunal.
Let us see your what averments you have made regarding these two advertisements before the tribunal.
The original, yes, my lord. If your lordship kindly come. My lord, the way application relevant portion starts from, my lord, page 23.
General, regular, yes, which paragraph?
Yes, my lord. Paragraph page 23, my lord. It starts. Now, if your lordship kindly comes to page 24. 24, Roman 4, my lord, I am reading. Can I read or you?
We are reading, just allow us. And where is the reply to this paragraph 5?
Before the tribunal, my lord.
Roman 5.
Before the tribunal, my lord, they have not filed.
Here you have filed. What is your reply?
Lordship, kindly come to page number 3, Lordship, of my affidavit in opposition. Lordship. Lordship, may I read, Lord? May I read, Lordship?
The December. সমাজের ডিসেম্বরে সিকিমে আছে এতে সেখানে জয়েন্ট রেজিস্টার শুরু আমাদের করেছিল তাহলে নিজের মধ্যে শুয়ে দেবে ওই করি ঠিক তারা জীবন চার্জার দিয়ে করে চারটে স্ট্যান্ড বসে গেছে চারটে চারটে না তিনটে স্ট্যান্ড চারটেও তিন মনে হয় না আমাদের অনেক ছিল না আমাদের টেন্ডার করেছিল তো তিনটে না চারটে ছিল Yes, we have seen it. Where is your denial to this assertion?
Lordship.
Your answer is from page 4 up to page 8. Where is the denial that no, two advertisements were not uploaded?
Lordship, the first advertisement which has been made, Lordship, it is
No, just show us the one line that no two advertisement have not been, two PDF has not been uploaded. Where have you said that? Just read that one line.
Lordship, what happened, Lordship? Page number 4, Lordship, at the top, Lordship. Kindly come to page number 4 at the top. Whereas the first PDF was created at 11:35 on July 21st, 2020. The second PDF file was created at 15:3 on July 21, 2020.
That is what we are saying. Where is your reply to this? That no two PDF forms were not uploaded.
Lordship.
That is their submission. Where is your reply that two PDF forms were not uploaded 3 hours apart?
Lordship, firstly, what I humbly submit, Lordship, that this writ petition, this WPST is no further maintainable at all. Lordship, kindly come to page number 7 of my affidavit in opposition, Lordship. Just once, Lordship. Page number 7, Lordship. Lordship. Paragraph number third paragraph. I further say that the advertisement has been accepted and accordingly the petitioner took part in the recruitment process. So at this stage, the petitioner has no right to challenge the advertisement after appearing the examination and when declared unsuccessful.
Which advertisement has been accepted?
Second advertisement. Because the first advertisement which has been made, it has been made and that I have also submitted, Lordship. Kindly come to paragraph number E, Lordship.
Paragraph E.
Paragraph E, page 7 only. I say that in paragraph 5 of the aforesaid writ petition, it is stated that the regular employees and contractual employees of the government were treated at par for the purpose of age relaxation in the recruitment process. It is also claimed that the said relaxation was removed for the contractual employee in the surreptitious manner without issuing any corrigendum to that effect. Page number 7, Lordship.
Yes.
Lordship. First paragraph, Lordship. However, Lordship, next paragraph, page 8, Lordship. However, it appears from the available office records that the advertisement being number such and such dated 21st July 2020 clearly states that the claim of the candidate for relaxation of age of a regular government employee should be proved by a certificate from the appropriate authority showing the periods of candidate's continuous service from the government of West Bengal and same should be furnished when called for. So my humble submission before your Lordship that the first advertisement was published. It has been published at the time of 11:35 and it has been withdrawn also at the time of 15:3. But the thing is that without giving any corrigendum of withdrawal. The petitioner has accepted the second advertisement. He has seated for the examination and he has been unsuccessful. Regarding...
Please. Yes.
And he has accepted the said second advertisement and as per the norms of the second advertisement, that is note 6, Lordship, that is the of the writ petition, Lordship, page number 65, Lordship.
Where have you said that he participated?
Lordship, that is in my affidavit in opposition, page number 7, Lordship. Page number 7, third paragraph, Lordship. I further say that the advertisement has been accepted and accordingly the petitioner took part in the recruitment process. So at this stage, the petitioner has no right.
He has submitted an application form.
Lordship. Lordship, kindly come to page number 11, R1 of my affidavit in opposition. Lordship, he has attended. This is the document, Lordship. Vidyut Samanto, petitioner, assistant superintendent, non-medical, grade 2. He has attended. Lordship, next page number 13, Lordship. Vidyut Samanto, name of the post, assistant superintendent, non-medical. He has given. Page number 14, Lordship. Declaration, copy of interview call letter, copy of application form duly signed, everything, Lordship. Experience certificate, private, no. PG degree certificate, experience certificate, PG degree certificate, no. Page number 15, Lordship. Next of the second, this is the page number 16, Lordship. Regarding the advertisement, the document has been verified.
What is the difference between page 11 and 16?
Lordship. Lordship, page 16 is the form which has been, this is the documents, that is the interview call letter. And page 11 is the stamp is there where he has been attended.
So it is the same paper, but
Thing is the same, but he has attended, that stamp is in the page 11. And this has been the call letter which has been issued. It is in the page number 16. And after his appearance, that is in the page number 11. That is, he has attended the interview. The authority has called for the interview and he has attended the interview. That is page number 11. Similar with the petitioner number 2 also. Similar with the petitioner number 2, that is page number 18, that is he has attended and all other such documents. So, Lordship, my humble submission, Lordship, he has accepted that.
Did he submit the proof of his working on a contractual basis?
Lordship,
Where is that?
without such, he cannot apply for the post only. He has been applied for the post of contractual only.
Page 52.
Page? This cannot be.
Petitioner is a contractual basis in the post of ASHA facilitator. Lordship, kindly come to page number 17 of my affidavit in opposition, Lordship. It is his form only which he has been filled up, Lordship, whether in service, government, contractual. Reason, as a regular government employee should be provided a certificate from the appropriate authority.
Where are we reading?
Page number 17 of my affidavit in opposition, where the petitioner's, his own declaration, his own signature is there.
Yes, what does it say?
Lordship, kindly come to the right hand side, Lordship, after the photographs, that is one column, Lordship, whether in service, government, contractual. That is the reply of the petitioner.
Page 8 of that. Yes, that's all.
Lordship, my humble submission, Lordship, kindly come to page number, Lordship, 9 once of my affidavit in opposition, Lordship. So moreover, first, Lordship, moreover, this word that is as a regular government employee has been mentioned in the advertisement as well as an application form. Furthermore, in the note portion of the documents, verification cum interview call letter issued to the writ petitioner, it is clearly stated that whether in permanent service in Government of West Bengal, NOC from the appointing authority to be submitted in the time of interview. And hence the claim of the petitioner in para 5 of the aforesaid writ petition seems to be unjustified and doesn't sustainable in the eye of law. So my twofold submission, Lordship. First of all, that petitioner has accepted the second advertisement as because the first advertisement which has been published just for few hours and it has withdrawn by the authority, and such has stated in the order of the tribunal also, which the tribunal's order, Lordship, kindly comes to the tribunal's order once, Lordship. Lordship, tribunal's order once, Lordship. Lordship, may I read the tribunal's order once, Lordship? Lordship, the tribunal's order, Lordship. It appears from the contention of the applicants that the advertisement quoted 21st July 2020, contractual workers were also covered for the age relaxation. That is a recent order passed by the Secretary and Controller of Examination on 3/1/23, publication of such an advertisement allowing the benefit of the age relaxation to contractual worker is denied. The reason order mentioned that only one advertisement being such and such was issued on 21/7/20, in which such age relaxation was not made for applicants working on contractual basis in the government sector. Such age relaxation was available only for the government employees. Further, the reason order distinguishes between regular government employees and those.
Where is the reasoned order?
Reason order. Lordship, page number 98. 98.
98.
Page 98, Lordship. Type page is page 98A, Lordship. The reason order clearly states about the advertisement, Lordship.
Yes, anything else?
Lordship. So, my humble submission, Lordship, he has accepted the second advertisement, and as per the second advertisement,
That is not something else. That is you have already.
that I have said. Now, the reason order, Lordship, let me kindly read one paragraph, Lordship. Reason retenable behind order.
Yes, we have gone through it. We
Lordship.
have gone through it.
So, this is the thing, Lordship. Though one application has been uploaded, but such has been withdrawn. The thing is that no corrigendum has been passed, but such has been withdrawn, and the petitioner has applied as per the second advertisement. And as per the second advertisement, the norms and regulation, he has not qualified in that said case.
Yes, Mr. Mukherjee. Anything else?
The advertisement published on 21st July 2020. Yes, applied. Letter was issued. And
Once an advertisement is uploaded, it can be taken down anytime without anything. After 2 minutes, if it is permissible after 2 minutes, it can be permissible after 2 months also. If it is not permissible after 2 months, then even 2 minutes it cannot be.
Second advertisement.
Second advertisement. As in for a moment, advertisement was published, yes, accepted. And yes, approach the traveler accepted by.
What is the relief before the tribunal, claim before the tribunal?
না ওটাতে মিলবে না ওটাতে মিলবে না item number 6 prayer is at
Page 46. 46.
starting from 46
Contracted as and the department was selection process for post medical. After that,
when he has already
In the tribunal.
not
Saying that the second advertisement was
interview affidavit এ বলা আছে attended
he is saying is too bad because what you have. So after participating in the interview, what happened? Result was published. Result was published.
not eligible. Lordship, kindly come to page number 12, Lordship, of my opposition. Not eligible overage.
Page 12.
Page 12 of my opposition.
page 16 of my.
না ওটা তো দেয়া নেই এখন দাঁড়ান ওটা দাঁড়ান
Page 12 is
of my affidavit in opposition. Yes. Lordship, kindly comes to the last portion of the overage, not eligible overage. Similarly, of the second writ petitioner also, Lordship, that is in the page number 19, that is also same, rejected due to age, overage. So when he has been rejected, he came before the honorable court. He has accepted the advertisement. He has been seated for the examination. His
interview, not examination.
Interview. He has attended the interview, that is in the page 11. And when he has been rejected, he came before the honorable High Court. And he is a contractual employee. His own application given that, that is in the page number 17 only.
Page 17.
Page 17. His own
No, that
standard.
he is not disputing that he is contractual.
Yes.
He is saying how you can discriminate between contractual and a
And he was
regular
no position to say at this
in view of
moment
the
when
first.
he accepted the second advertisement he applied for and he has been rejected in that said ground. If he has been applied a
How many times you will submit that?
lots, more than lots.
Overage.
Order passed by the
Recent order.
page 191.
119.
98. Reason order.
We have read that.
Appears for the available officer for that on the advertisement number certain was issued for the post of superintendent non-medical which clearly stated is not more than 36 years as of first service as per government right number dated 13 January 2000. Provided the age limit is acceptable by the for the candidate belonging to the categories of scheduled caste, and other backward class of government or other. The candidate shall to perform the then the name of the candidate for relaxation of wage as a regular government employee should be proved by certificate from the authority. Why? The candidates continuous party after the this is the only advantage. Only advertisement number. Again, 57. Only one advertisement.
What is this at serial 12, page 15?
Page 15. Page 15
Of your opposition.
serial number 12, experience certificate government. Yes. These are the checklist for the candidates. What are the checklist documents have been given? This is the checklist series.
What is this? Serial 12? What is this serial 12 at page 15?
At the time I was, since I was allowed to fill up the application form, I was given an admit card, call letter for appearing. I produced before them my contractual experience certificate to which they have marked it as yes. And after that, my lord, they check that no, this is not, you are not a regular employee, your candidature is rejected. And I approached this court because admittedly, my lord, I was 36. I was allowed to fill up the application form. I was of the opinion that there are two advertisements, none have been withdrawn, I would be allowed. When I was rejected, I approached this court. It has not been denied.
But this stand is not sustainable. And prior to passing of the reason order, you had earlier approached the tribunal also. Where is that order?
In the page 97.
Tribunal's order.
Page
97.
Section.
And where is this representation of 27/9/22 referred to in the order?
Lordship.
Was not fixed in the original way application, my lord, so it is also not. In the subsequent second original application, that since the reason order was first, that was not added, so my lord,
What you were claiming, we want to see. Where is, you have a copy?
my lord, I am claiming that
Where is the claim? We are not asking you. We want to see what the applicant's claim was in the representation.
Representation is not. Tribunal is clear. Reason order is not there.
yes, the order taken, not the other different.
Yes.
In the second way, yes, not the
Correct.
split into agenda.
Hmm?
It is the original. Consider that presentation was not annexed before the tribunal, it is also.
No representation.
Anyway, what you are claiming is here. That's the part. That's the
Section in that.
second advertisement was taken. So after 3:05 p.m., 3 p.m., the first PDF was gone.
My lord, there was no official, in the second advertisement, it was not written that in supersession of the RDR or in cancellation, nothing was there. So, till date, there are two advertisements. My lord. And there has been no denial either in the.
Till date, there are two. You yourself have said that at 3 o'clock it has been changed. Then how you can say that till date there are two?
It has not been withdrawn, I say.
It has gone from the website. That is an admitted position. Therefore, you cannot say. What is this? There is any difference?
It is different. It is different, madam.
Huh? What is?
Let-
So my pardoning your lordship, the number, page number will be different. Otherwise, everything is same.
And the order is composite or the separate order?
Order
separate.
date is also, my lord.
Petitioners are different sets.
There were two original applications filed.
Say that taking everything issue. It's caused away. Should not have. Challenge the cannot be done. Really? Consider me. Yes, you want to say.
Presentation, my lord.
Not required. See, it has been noted.
Yes, my lord, I was, paragraph 4 of the reason.
Correct, that we have seen. Therefore, later I pointed out to his lordship that it is there. The two advertisements for the bus. Our learned advocate for the
Item number 9.
My lord, my my senior is appearing on for this petitioner, and because of a family accident, his younger brother had a major road accident, and he is into Institute of Neuroscience, and he's going through several operations, so he would not be available this week. So we pray for next week, my lord.
Lordship, my affidavit has been submitted, Your Lordship. They are supposed you to give the reply.
When did you submit it?
I shall give Your Lordship. 18th March, Your Lordship.
Oh, petitioner has to file the reply. They have to file the reply.
Yes, Your Lordship.
Still, you are.
Item 10.
So item number 10, Mr. Showroom model lapping for the petitioner last two. Lordship, he is lying in last two. Covering for fever.
Can you use the mic, please?
Lordship, Mr. Showroom model lapping for the petitioner Lordship. He is lying ill, suffering for fever, Lordship. I'm praying for not this week, Lordship.
Same order.
I am appearing on behalf of the respondent.
Give your opinion.
Item 11.
Even I'm praying for short pass.
Not good.
Item 12.
11.
Just now he sought a adjournment.
I prayed for short pass. Short pass to and just time. Yes.
So you should tell us. Give 11. 11. Yeah, painted recycling.
The graphic is too.
Also been replaced.
Yes, sir.
Yes, sir.
And the petitioner করাই ভালো হ্যাঁ
Shamal Kumar Mukherjee. It's for the Union of, you are for the Union of India.
But the petitioner before your lordships was a cabin master, my lord. At TPF, and he was working, but since 20th May 2005, my lord. He reported sick while he was discharging his duty due to spondylitis, and thereafter your applicant admitted for treatment under senior DMO, RPH and Howrah Orthopedic Railway Hospital. Thereafter, the applicant was decategorized staff on 17th January 2006. That is on page 21, 22. Lordship got it. Page 21, 22. The petitioner was, you are hereby informed that you are unfit in medical categories from etc. and appeal for a decision. You may appeal immediately within 7 days of the receipt of this letter to the Chief Medical Director, Eastern Railway, etc. in KG building through proper channel. Thereafter, petitioners made immediate representation. That is annexure P3, page 26. But in the meantime, the petitioner's salary was stopped. Salary was not given as he was decategorized. That's why the petitioner requested for paid his salary. And also, the petitioners on 5th April 2006 offered technical grade 2 scale of rupees 4,000 to 6,000 by the respondent authorities by letter number dated 5th April 2006. But the said post was not been accepted by the applicant, as the doctor recommended to the applicant for fit only for the sedentary job. That is page 23 to 25, annexure P2. Also, Shubir Kumar Chaudhary, na? Can see the first paragraph, second paragraph. Say Shubir Kumar Chaudhary, date of birth approved for the post of technical grade 2 in the scale of rupees 4,000 to 6,000 in mechanical CW department. But the petitioner has not been accepted that scale because it has been advised by the doctor that he is to be fit for only for the sedentary job. Thereafter, the applicant made representation for his absorption in the post of sedentary job in reference of senior DMO, HWH, height number ato, and the same was duly received by the respondent authority. On 18th April 2006, made representation. So there was no remuneration since 20th May 2005 to 4th October 2006 to the petitioner. Though the petitioners made several representations, even then that has not been paid. Thereafter, the petitioner was decategorized in the initial grade of rupees 3,200. His pay has been decategorized. 3,200 to 4,900. At the same time, the respondent authorities provided grade of rupees 4,000 to 6,000 to another similarly circumstances person whose name is Subroto Chatterjee. I have stated in paragraph number G, page 4. He has been paid, though his case is similar to the petitioner.
Where is your OA?
My lord?
Where is the OA?
Wait, Mr. Kurishni. Wait, annexure. That OA has not been annexed herein, but should be annexed to A.
So we don't know what is your case.
Order is here.
So that is, then there's nothing wrong with the order then.
No, lordships kindly see the.
What lordship kindly see? The order is there for your case, and for everything order is not tenable.
Why not?
You are arguing a case, why you have not
Why
asked?
not tenable, my lord? I am submitting.
How do
that.
we know unless we know what is your case? Everything in air. Wonderful.
I have stated what is my case in paragraph.
Why should we rely on the writ petition?
Then lordship.
You are a seasoned counsel, you are not a new counsel. You should be saying, asking your instructing counsel to place it on record. How we will know what is your case?
That I have said, but lordship.
Then why you are making such excuses?
Supplementary affidavit, my lord.
Why you are making such
I am
excuses?
praying for supplementary.
We don't want to allow without cost. You are obliged to file everything in the first instance. Why supplementary affidavit? If your client has so many resources, give something to the legal aid also. This is a sheer wastage of time.
Correct.
Let supplementary affidavit be filed.
I'm sorry, no. I think. Sorry, sir. Sorry, sir.
Tell them.
I'm sorry, sir. This is my interest.
112,
I'm for the respondent. There is a restoration application.
There is a restoration.
Restoration.
Restoration is allowed on 5/8/25.
এটা বললে কেন আমাকে? Appointment on compulsion.
Is allowed. There is nobody is there. Not today. There is some resolution which we have received.
and 13,
But I am for the petitioner, my lord. This is a case of a land loser scheme, my lord, of Southeastern Railway. This honorable division bench already dealt with the matter, my lord, for so many orders.
When we have kept those matters?
The matter fixed on 10th November.
My lord, I have checked the Supreme Court also, my lord. They have only filed no follow-up action, only diary
But
number has been given.
the
They have filed this till date, the diary number has been generated. Nothing has been followed. They have not followed.
let's call the next case.
and 14,
I am for the petitioner.
You have served copy of the paper book. Have you served a copy of the paper book?
Mukherjee is appearing.
Yes, he was here just now. Now he's gone.
This is mine. I have the
One such paper book. Apply another set of left. Let us see of this CMP what is 26.
Mukherjee.
Have you got a copy of the paper book?
Yes, my lord. Yes. My lord. My father, my lord, was the staff and government employment. My father died on my lord 24th of April 2010 month.
24 April? 24 April 2010.
24 April 2010.
24/4/10.
Then
We-
when the petitioner
He was working as
was service and government employment lord, under the my lord, director of animal and husbandry and veterinary service. Animal and research.
he was Gola.
Voila. He was holding the post as Voila.
What is God? Huh? It looks circular. There is a post.
That page 38 one. This 38 one, date of death certificate.
You applied on 28/12/12.
December 2012.
28/12/12.
While a petitioner mother applied on 14 June 2010 for his son, my lord.
Then what happened? She is
My lord, the petitioner, my lord, when the application was not considered, the petitioner moved before the West Bengal State Administrative Tribunal. The Administrative Tribunal was pleased and directed the authority to pass the reasoning order. So the first order, my lord, I place him before your lordship. First order, my lord, page 91. 91, page 87 first, when I moved before the State Administrative Tribunal. 87. This first time order, my lord. On order was passed on, my lord, 11th April 2022. Last para, my lord, the respondent disposed of the representation by putting a reasoning order of the and communicated to the petitioner within 15 days. This is the order, my lord. Last, my lord, page 88 order has been passed. 15 days, 15 weeks. 15 days. 15 weeks. অর্ডারটা কমিউনিকেট করে হচ্ছে The Minor authority passed the order 691. Authority passed the order in 91, my lord. Last para, my lord. Consider the matter, my last para, my lord. Para 5, 3, my lord.
yes, this was challenged.
Again, my lord, I challenge before the learned tribunal, my lord, as an order of that page 93.
How this can be? Oh, this is 23.
On this last para, my lord, page 95A, my lord, the Secretary Department of Animal Resources Development to reconsider the application for compassionate employment and passed a reason order and speaking under the relying all specific government rules under within a period of 8 weeks from the date of communication of this order. So reconsider order was passed again. Again this order, my lord, 97, my lord. Again that order, my lord, again, my lord, the authority passed the order. Page 98, my lord, clearly said, my lord. Against the order of the authority, again further I challenge. 134. Under challenge before this honorable court.
Where is the order of the tribunal? The speaking order of 23/8/23 was challenged before the tribunal. Which OA? OA number?
7 of 2023.
Sorry.
717 of 2023.
Last order, my lord, 717 of 2023.
3. Where is that order?
Under challenge before this honorable.
Which page of the paper book?
134.
134.
134. Last matter I be reading, my lord, only para. You got it, my lord. 134, my lord. Typing copy already there. I have annexed, my lord. The normal circumstances are provided by the scheme. Such application could have been prepared before the uh, within 2 years from the date of death the employee. If this employee Kalipodo Sardar had expired on 24.
Oh, what happened to the mother's application?
That was not considered. Well, it is marked, my lord, by this before this tribunal. Your application was made by the mother in time. In time, within 2 years. That is, my lord. This paragraph already it appears from the paragraph. My lord, kindly see.
So mother is still alive.
Mother applied within 2 years.
She is still alive. Then how it can be changed?
He made an application for appointment his son.
Where we are asking you what happened, you are saying pending.
Page, my lord, mother's application page. I'm showing you the mother application.
Mother applied on 14 June 2010. You are saying then thereafter she has asked that the son should be appointed. Where is that request?
Mother already applied, madam. I understand, madam. I am sorry, madam. I am not clear. Mother, my lord, applied on 24 June 2010.
On 14/6/2010, she has applied. She applied for herself or she applied for her son? Oh, so the initial application was for the son. And he was eligible on that date. Then where is the question of delay?
Under the 2008 circular, 6 months from the date of the death. Application will be rejected on the ground of time limit. For 2 years, something.
They have filed affidavit in opposition. Can you see their affidavit in opposition?
Now you are saying that it is beyond 2 years. You are not saying beyond 6 months.
Yeah, but under 2008 circular, 6 months.
No, but you are rejecting it because it is beyond 2 years. So therefore you are applying the 26 EMP. Your officer has applied the 26 EMP. He has said it is beyond 2 years.
2 years because of 2013 circular.
Yes, 26 EMP.
26 EMP.
So therefore once 26 EMP applies, then beyond 2 years also it can be considered. But beyond 2 years it cannot be considered.
Can see page 98. In the present case, the date of the deceased employee is on 24th April 2010, and the date of submission of the application for appointment is 28 December 2012. So the applicant applied for appointment as in compulsion appointment after 2 years from the date of the deceased.
Correct. After 2 years, that is what we are saying.
And for making an application cross the by date of clause 4 of 30th EMP dated 2nd April 2008. Because death took place in 2010. And 2008.
No, that took place in 2010, yes.
Yes. And when 2000,
They applied on
30 EMP 2nd April 2008 circular will be applicable.
14 June 2010 applied.
But he is saying she has applied on 14/6/2010. In your OA, where is that averment that she applied on 14/6/2010?
Kindly 155 of their affidavit in opposition. Kindly see their affidavit in opposition. Page 155. Last occasion, your lordship, I pointed out, your lordship also.
Where have you said that she applied on 14/6/2010? Where is that averment in the OA?
Within time, my lord. Within two years, she applied for his son.
What is the date of application? Again and again we are asking you.
On 14 June 2010.
Where is that averment?
That application, my lord.
Show either from your OA or show the application.
Para 45.
Page
45.
45.
What is the prescribed format?
Not in the prescribed format. So when he has submitted the prescribed performer.
And already applied 46.
What is the date?
December 2012. Page 48. Bottom left hand side. 28 December 2012.
December or this 28/12? Oh,
28/12/2012. Clause 4 or of the 2008 circular is standing on it. The dependent of an employee seeking an appointment or completion round shall henceforth make an application in the prescribed format within 6 months from the date of the deceased employee. If no such application is submitted within the stipulated period, it will be presumed that the family does not require any.
My lord, 53, my lord, 5-man committee also recommended. Well, 5-man committee was appointed. 5-man, my lord, 5-man committee.
yes. 14/2010. For application on performer. More than 2 years. 28/12. Now we are in 25. Yes. 6 AM. 10/B. This direction. This requirement. 6 PM. By paper. We expected to buy it before 1/3.
Lord, 5-man committee also recommended my application, my lord. Page, my lord, 53.
Three-man committee has recommended.
Yes, my lord. Page 53, last para. For first month of the disbursements of such and such amount along with my last page, my lord, last para, my lord. Date of the recently such and such and recommended the application for appointment.
Is something amiss somewhere. They are saying that pro forma application has been made on 28th.
Really distress committee, man.
There is this recommendation is of 21/9.
My lord, cannot be. Appointed 5-man committee.
Mr. Mukherjee,
Kelly, my lord, 155.
see page 53.
53, the committee has recommended. The recommendation of the committee depends upon the ultimate decision of the government. Appointing authority is the government, and it will go to the cabinet committee on appointment. According to the circular.
The committee examines the declarations made by the person in the forma, in the pro forma.
Whether he is eligible or not.
But it examines the declaration made.
A declaration whether it is correct or not.
For the purpose of eligibility.
Eligibility.
And after finding eligible, they recommend.
They will forward their recommendation to the government.
So once they send a positive recommendation, can the government decline?
Provided the government is to take independent decision according to the circular issued by the government.
Where it says that even after the committee has recommended, the government has to examine?
Is there any circular order provisions in the keeping otherwise that whatever may be the recommendation is binding upon the government?
No.
It is a committee may recommend. It is ultimate.
So therefore, if the secretary finds some infirmity in the committee's recommendation, we say it is a recommendation. But it is not a recommendation which is futile, because it is after examining all the parameters of destitute, whether there is sufficient income, whether they have any other source of income, whether they are eligible, everything has been examined. Whether it is below 90%, whether it is less than certain group D staff.
That will be considered by the committee, not by the.
So none of these findings have been disputed by the secretary.
Yeah.
None of these findings.
Yeah.
Then
only the government rejected on the ground of clause 4 of the 2008 notification. Can you see the language of 2004 notification? Another submission, I'm taking leave. Clause 4. Another submission, they have filed affidavit in opposition. Page 55, 155, can you see their circular? It is their circular, my lord. The affidavit in opposition, they have annexed, my lord.
30 MP. You are relying on 30 MP.
I am relying upon 30 MP. Clause 4. Finally, 155 page, their affidavit in opposition. It is their circular, madam. 155, my lord. The concern may I read, my lord? The concern authority in the Department of the 5 should meet the members of the family of the deceased government, uh, government immediately after the death of the deceased, and then in putting a appointment putting a appointment on the compensation ground, the applicant should be called in question very first stage, and should be advised in present about the requirement and formalities to be completed by him. A record of such meeting should be kept with the office of the controlling authority and appointing authority.
Is there any provision how the three-man committee has to consider regarding consideration by the three-man committee?
In BB are already clear said.
Clause 6 only the recommendation is made by the committee, it goes to the government, and then government it approves it, then it will go to the
No,
committee.
this three-man committee is constituted under which provision?
In 97 notification.
97.
The pro forma.
It is their circular. After the death, then nobody came to the house of the deceased father. No advised them. No supplied any prescribed form. It is their circular.
One thing we have observed on the last date, and you have just you are stuck on that only,
It is their
and you are repeatedly saying the same thing. And what you are relying upon has come into existence in 2016. So before 2016, how they can go to your house?
their circular. In BB, my lord. Page 55, 155.
I'm saying when she has filed is they have considered in September 2020, they have forwarded the recommendation.
In 2002. That was 2008. But can you see the references? They are at page 4. Committee's provision is there. Right, current data near declaration of an employee who died in harness may apply to the appointed authority through the head of the office of the employee in a prescribed form as per part 1 and actually along with the death certificate for it. It is a submission of the committee. The committee so far shall make an inquiry. Have you also got it? Committee so form shall make an inquiry about the justice of the player as well as the physical committee. The judicial praise submitted report as per the appointing authority. He will forward the case to the record answer, additional department, concession. If it is decided that the fit case for employment on completed ground, a suitable vacancy may be identified under the appointing authority concerned for providing employment subject to the condition. The candidate satisfied the qualification and other requirements prescribed for equipment to the post. Suitable vacancy is not available under the appointing authority concerned. The administrative department may identify suitable vacancy and some other control of the employer. In the event of non-ability of the move other department for suitable cases. If suitable vacancies are some other department. The department has vacancy. You will issue the this is the condition mentioned in 2008. The 2008 circular said, paragraph 5, all other conditions laid down in notification number 301 ENP and 303 EMP dated 21st August 2000 to the extent are not inclusive provisions laid down again shall continue to apply. It means when a 2002 circular, there is a formation of committee.
Hello, kindly one.
data which was required to be furnished along with the form.
No. They have filed the applications not in the stipulated period of time as per clause 4. That's the only ground taken by the government.
No, that ground is,
Because of the last sentence of the clause 4. If no such application is submitted within the stipulated period.
where is that?
The clause 4 of 2008 circular.
26,
30 MP. 30 MP.
30 EMP,
Paragraph 4.
2008.
Yeah.
Clause 4.
Clause 4. Last sentence.
Then you come to page 120. 120. Ah. You read it.
My lord, 155, my lord, you lordship kindly their circular. 155.
Yes, how many times you will say 155,
14
14 double B, 14 double B, 14 double B. You have continuously been saying that. And 14 double B has come into existence in 2016. How they can go to your house in 2010, 11, 12, 13, 14 and 15?
They realize this order has been passed.
How they can go to your house in up to prior to issuance of 2006?
14B, my lord, when I have made all the application is pending, within 6 months they will dispose of. It is their circular. All the representation. Other have applied within time. It is order of the Honorable State Administrative Tribunal. It appears that the mother already applied in time. It is record. Order has been passed by the Honorable State Administrative Tribunal, which is under challenge 134. Already said so, my lord. The mother already applied in time. Well, I am reading, my lord, just. In normal circumstances that provide the scheme, such application should have been prepared before the respondent office within 2 years from the date of death of employees. The deceased employee Kalipodo Sardar had expired on 24th of April 2010 while serving at Gwala at Behala. The mother of the applicant had submitted an application for such an employment for her son. The present application on 14/6/2010, which was within the admissible period of application. This matter recorded, which is under challenge. But this receipt was not eligible. Only mentioned, my lord. Ending of the tribunal, my lord, already applied in time.
Not correct. Any judgment of this court that filing of non-filing on the pro forma will not be fatal. Is there any judgment? Are you aware? You have to know.
But they said, my lord, the application was not made within 2 years. Mother was eligible. Mother, she prayed for her son. And also, my lord, Five-Man Committee recommended the family is under starvation. The Honorable Tribunal, my lord, appears, the order of the Honorable Tribunal that the family is not under the starvation. But Five-Man Committee already said, my lord, starvation.
आप करते हैं pro forma just supply yes 2002 M. Page 4 of this compilation. Paragraph 1, subparagraph Annexure A. Pro forma, that's right. I've got a copy of the pro forma.
Employee who died in harness may apply to the appointing authority through the head of the office of the employee in a prescribed form as per part 1 and 2 of annexure A. Where is this part 1 and 2 of annexure A? And then report has to be submitted as per annexure A by the committee. So where is part 1 and 2 and where is annexure A both? Just see 2 lines after that. On receipt of such application, the appointing authority shall form an inquiry committee of senior officials not less than 3 in number. The committee so formed shall make an inquiry about the genuineness of the prayer as well as financial condition of the family of the deceased and submit a report as per annexure A. So both these documents, where are these documents? Must be there in some EMP. Huh?
That is in the labor department. But my land fund clients submitted a form in the prescribed form.
Huh?
My land fund clients submitted a application in the prescribed form.
That is on record.
That is on record, but I have got a copy.
Not on record. Where is the form you have submitted? Which page?
Page, my lord. Page, my lord, 46. Yes, 46. And 48 is the date.
And what is the pro forma for the report by the 3-man committee?
রিপোর্টটা কোথায় দেখো রিপোর্টটা রিপোর্টটা হ্যাঁ
Hmm? This is not annexure A. Page 53 doesn't appear to be spot inquiry report. In terms of memo number so and so of 24/7/12, this is not annexure A.
No, no, this is the formation of the committee.
The forma is not available. Then we'll reserve the judgment. Heard the learned